In this segment, I will mostly focus on the lawsuit I filed against Al Pacha on November 24th of 2015. That is 7 days after I discovered that Al Pacha made his false and defamatory statements to the University of Michigan. At that point, I had approximately 3 months of litigation experience because of the lawsuit I filed against the stepmother Maria Vigers. That was the period during which the University of Michigan inexplicably concealed from me the fact that also this coward intermediary Al Pacha participated in the rampage of defamation of which I was the target, and which he began within 6 hours of the personal protection order being served upon Maria Vigers. I served the complaint upon Al Pacha through the services of the Washtenaw County Sheriff's Office, which is more expensive than by certified mail with the USPS, the United States Postal Service. But my reason for doing this more expensive option is that I didn't want to give Al Pacha the opportunity to make another false accusation like the ones he made in July of 2015. By having a police officer personally deliver to Al Pacha the summons and complaint, Al Pacha would be unable to make up his false stories in the sense of me sending direct threats to him. Usually the sheriff's office is pretty quick at delivering court documents, and I know that because I hired the sheriff's services for delivering several subpoenas in my lawsuit against Maria Vigers. But this time it took 2 or 3 weeks for the police officer to serve upon Al Pacha the complaint, and I don't know the reason. Maybe Al Pacha was hiding in his basement whenever he saw the police car approaching his address, more so because Al Pacha could foresee that I was going to bring legal action against him after he received my request for retraction on November 17th of 2015. In the meantime, Finley the Idiot, in my lawsuit against Maria Vigers, submitted to me a request for admissions. That is a document where a party essentially requests the adversary party to stipulate to a set of statements of fact so as to simplify the discovery process in the lawsuit, and also to simplify the issues that a jury or a judge needs to ascertain or to decide. Apparently, Finley the Idiot was ecstatic about the deposition testimony of Luckland Gentles regarding the statements of threat which Al Pacha falsely attributed to me, and therefore Finley the Idiot's request for admissions contains repeated questions or repeated statements that he wanted me to admit. It was incredibly stupid for Finley the Idiot to expect that I will endorse Al Pacha's false accusations, given that I had just begun my complaint or my lawsuit against Al Pacha. Finley the Idiot knew actually that I had just sued Al Pacha precisely for the defamatory statements that Al Pacha made to the University of Michigan. Maybe Finley the Idiot was feeling so smart in his kitchen business and saying, "Oh, look at me, I have a variety of ideas to request for admissions." Al Pacha retained the services of a law firm which from the beginning filed the appearance of 2 attorneys instead of just 1. It was strange for me, more so because later on I realized that this law firm usually assigns only 1 lawyer per case, not 2. It was interesting that now on this occasion they were assigning 2 lawyers to litigate against a pro se litigant who is not an attorney and who has never gone to law school. Then when I took the lawsuit to the Michigan Court of Appeals, this law firm added a 3rd attorney. By the time I got Al Pacha's responsive pleadings, I had already obtained important evidence about which I wanted Al Pacha to testify at his deposition. Therefore, as soon as I got the responsive pleadings from his attorneys, I scheduled Al Pacha's deposition for January 21st, thereby giving him 2 or 3 weeks of notice or of anticipation. Together with the responsive pleadings, the attorneys of Al Pacha also included a schedule or a notice for my deposition, scheduling it for February 24th of 2016. It was odd that they were scheduling my deposition with so much anticipation. Anyway, when Attorney Gatti requested me to postpone the deposition of Al Pacha, she made the poorly thought excuse that she was unable to attend the deposition of Al Pacha on January 21st. And I explained to her that that doesn't matter because Michigan court rules only care about the witnesses' availability to attend a deposition. Michigan court rules don't care as to whether the attorney is available to attend the deposition. Moreover, in this case, they had assigned 2 lawyers, so if Attorney Kathleen Gatti was unable to attend, they could easily send the other one and problem solved. Attorney Gatti didn't like my answer, and therefore she filed a motion in court with the purpose of quashing the subpoena for the deposition of Al Pacha. Attorney Gatti made several vexatious arguments, one of them consisting of that the deposition subpoena that I submitted was improper. I don't know what she means by improper. As a non-attorney, I did what I was supposed to do. Every time I needed a subpoena, I had to submit it first to the judge's office, and once it has been signed by the judge presiding the case, here Carol Kuhnke, then I have to serve the subpoena to the witness and every party involved in the lawsuit. That's exactly what I did. In hindsight, the only improper detail about this whole thing is the issue that Carol Kuhnke was presiding this case. It was important for me to take the deposition of Al Pacha as soon as possible, because otherwise that will give him a greater opportunity to resort to fake amnesia, as Amy Carter Rano did, or to answer with attorney-crafted statements instead of testifying based on his knowledge of the events leading to this lawsuit. Attorney Gatti made the stupid allegation that because she was the first one to send a notice for taking my deposition, that entitled her to take my deposition before I could take Al Pacha's deposition. That argument has no support whatsoever in the Michigan court rules, and in fact it's a stupid pretext, because if that were the case, the attorney for every criminal will file right away the first notice of deposition of somebody else, and by scheduling that deposition for 3 or 4 years later, the attorney will be preventing anybody else from taking the deposition of the attorney's criminal client during those 3 or 4 years. Things simply don't work that way, unless the judge is as corrupt as Carol Kuhnke, of course. By contrast, the Michigan court rules entitled me to take the deposition of Al Pacha on January 21st, because the lawsuit had already begun, and also because the court rules gives conditions, alternative conditions, upon which a party is entitled to take the deposition of a witness or another party. By saying alternative conditions, I want to emphasize that any one of those 5 conditions is sufficient to allow the deposition, and at that point, by January 21st, I was meeting 4 of those 5 alternative conditions. In courts where judges are not as corrupt as Carol Kuhnke, there is a concept known as sequestration of witnesses, also known as segregation of witnesses, which consists of taking the witness out of the courtroom while evidence is presented in the courtroom or while other witnesses are testifying under oath. In that way, the witness outside the courtroom is prevented from listening to the other testimonies or evidence, and therefore he is forced to the extent possible to testify based on his or her knowledge, instead of crafting his testimony to make it sound consistent with the testimony given by his accomplices. Having explained that, here the situation was bad because Attorney Gatti's plan or fantasy consisted of that first I will have to respond to her very long and abusive set of interrogatories and requests for documents, which included the request that I produce any and all evidence of the case. Then Attorney Gatti would take my deposition, and only afterwards I will be allowed to take the deposition of Al Pacha. In other words, Attorney Gatti was destroying the purpose of sequestration of witnesses, because by giving to Al Pacha all the evidence, essentially he was given the opportunity to commit perjury without repercussions. That is, by having beforehand the evidence of the case, instead of testifying based on his knowledge of the events, Al Pacha would limit his testimony to whatever is in the evidence I have collected and conceal from me the rest of information that Al Pacha could have otherwise provided. I explained this risk in court, but Judge Carol Kuhnke didn't care about that, and she granted Al Pacha's motion on January 20th, thereby preventing me from taking Al Pacha's deposition on January 21st. The ruling issued on January 20th by Judge Kuhnke is sloppy because it didn't even contain any deadlines. The order should have set a deadline for Attorney Gatti to take my deposition or otherwise disable the sequence in which the depositions were to take place beyond the deadline, and the order should also have set another deadline so as to limit the length of time during which Al Pacha is allowed to continue avoiding his deposition once I have testified at my deposition. That is, the way the order was drafted and signed on January 20th, Al Pacha was given the opportunity to avoid for an indefinitely long time his deposition, regardless of whether I had already testified or not. Judge Kuhnke's obstructionist ruling on January 20th severely damaged the ascertainment of the truth. So in the meantime, my only option was to conduct discovery elsewhere, which at that point meant taking the deposition testimony of Ronald Lovelace, one of the employees of the university who met with Al Pacha on July 22nd of 2015. Once the University of Michigan notified me of the dates on which Ronald Lovelace will be available for his deposition, I had the courtesy, not the obligation, but the courtesy of letting Attorney Gatti know of those dates so that she would have a saying on for when I should schedule the deposition of Ronald Lovelace. Instead of appreciating my courtesy and answering me in a straightforward way in terms of her availability for that deposition, this ungrateful lawyer, Kathleen Gatti, only asked who the witness was, and she ignored my question. Of course, I know that Attorney Gatti's availability for a deposition does not depend on who the witness is, and she should not pretend it does. Therefore, I didn't answer this emasculating attorney's question, and I only told her that if she doesn't specify a date, I was just going to schedule the deposition for whenever it is most convenient to me. The deposition happened on February 8th of 2016, and at that time I gained some exposure as to how Attorney Gatti conducts herself during a deposition. Therefore, I was not so surprised of what a vulgar heckler Attorney Gatti was during the deposition of Al Pacha. Attorney Gatti postponed my deposition, which she initially scheduled for February 24th, and this time she didn't even mention a new tentative date. Because of course, Attorney Gatti was starting to take advantage of the obstructionist ruling by Carol Kuhnke. Instead of my deposition on February 24th, we had a court hearing where Attorney Gatti complained that I didn't supply or provide complete answers to her set of interrogatories, and for example that I didn't authorized, or I haven't submitted the signed authorization form for the disclosure of my medical records, insurance records, tax returns, and so forth. She argued that if I didn't authorize the disclosure of my medical records, I should be denied the recovery of non-economic damages under the argument that medical records are of great relevance to the assessment and quantification of emotional damages. Attorney Gatti's argument is wrong and misplaced. It is wrong because non-economic damages encompass more than emotional damages. Reputation and loss of consortium are two examples of non-economic damages which usually have nothing to do with the plaintiff's medical information or medical records. Here in my lawsuit against Al Pacha, another example of non-economic damages is the exemplary and punitive damages which I requested because Al Pacha refused to retract his false and defamatory statements when I sent my request on November 17th of 2015. Attorney Gatti's argument is also misplaced because in my complaint I never requested for the recovery of emotional damages, and there is no count in the sense of intentional infliction of emotional distress, which is the legal name usually given to the concept of emotional damages. The problem here was that Attorney Gatti was engaging in what courts call a fishing expedition, which is a term to signify when a party or an attorney requests the adversary information that has absolutely nothing to do with the case, and which is irrelevant to the case. And that is the tactic by which attorneys harass the adversary and obfuscate the matters in court, thereby confusing the judges and the jury. That's usually what attorneys do when they know that their clients have a weak position or a losing position in the case, and they realize the need of distracting the judge with matters that are irrelevant to the lawsuit. During the hearing on February 24th, Judge Carol Kuhnke also made showings of the fact that she just doesn't read the complaints and she doesn't read the motions of the hearings that she presides. At some point during the hearing on February 24th, she asked me, "Is it true that you do not intend to pursue any emotional distress, any pain and suffering damages, anything related to your body or your state of mind?" Had this judge read my complaint, the one I filed on November 24th, that is, 3 months earlier, she will be aware that I was not pursuing any of those damages that she listed. That was the same hearing, or that was the same date on which I had the other hearing in my lawsuit against Maria Vigers, where Judge Kuhnke said that her understanding was that all the evidence pointed to phone calls made by Maria Vigers around July 21st. This is what I described in the fourth segment when I was discussing the fact that Judge Kuhnke is totally disconnected with the records of the lawsuit that she presides. Another piece of information that Attorney Gatti wanted to obtain from me was my visa status and any documents related to that matter. Given that Al Pacha made his false accusations with the University of Michigan behind my back, I was not going to give this rotten intermediary and his crooked attorneys additional information so that now they can make their false accusations with the US immigration authorities. That will be stupid. At some point I mentioned that my visa status did not allow me to work in the US, but that I obtained that legal status because I needed to litigate these lawsuits in Michigan. Then at some point Attorney Gatti suggested that perhaps I should move to a country where I can work. So this is what happens. When I began my employment with Al Pacha, he made me sign an employment agreement where one of its clauses says that any litigation will need to happen in Ann Arbor, Michigan. But then when this fraudulent employer engages in unlawful conduct and his victim takes him to court, Al Pacha pays some crooked attorney to make this type of imbecile statement. I wonder what people with non-immigrant visas or former holders of a non-immigrant visa will think of this intermediary Al Pacha, who first profits from their work and then engages in some unlawful conduct and expects that his victims, Al Pacha's victims, will leave the country instead of taking him to court. That is nothing less than a criminal's golden dream. At the hearing on February 24th, Judge Kuhnke ordered me to produce several items which were totally irrelevant to my lawsuit against Al Pacha. For example, Judge Kuhnke ordered me to produce all my tax filings since year 2009, despite the fact that the events leading to this lawsuit happened in year 2015, and they had nothing to do with my tax filings. The IRS was not involved at all in this lawsuit. Of course, I had nothing to hide, and therefore I had no issues by producing my tax filings and signing the authorization of disclosure to the IRS. In any case, I was much more interested in taking the deposition of Al Pacha because, as you might recall, the situation was at first I will have to comply with these discovery requests, and then Attorney Gatti will take my deposition, and then I will be able to take the deposition of Al Pacha sometime later. However, it is outrageous that Carol Kuhnke ordered me to produce irrelevant information such as my tax filings so that I could take the deposition of Al Pacha regarding his defamatory statements in July of 2015. That is another example of how Judge Carol Kuhnke runs her court or runs her judicial office by making sloppy rulings instead of ensuring that the truth is ascertained. I will skip over the other details of Judge Kuhnke's incompetence on February 24th and on March 16th, and I will just point out as a side comment that in those hearings and also on January 20th, Attorney Gatti was asking for attorney fees for motions where she made false statements. Now, this frequent or this recurrent petition for attorney fees is a form of panhandling. I mean, it happens in court, but it's panhandling nonetheless. This is another showing of attorneys' lack of dignity by having to panhandle when in fact they are hired by their client to attend motions and to prepare the court document. On April 13th, there was another hearing, this time because Attorney Gatti wanted to quash the subpoena which I submitted to AT&T, Al Pacha's telephone service provider. The idea behind this discovery venue is similar to the one I described in the third segment, and which I applied in my lawsuit against Maria Viggers. It is through that discovery venue how I found out that the University of Michigan was concealing from me records that were within the scope of the subpoena which I submitted to the university itself. In this instance, in the lawsuit against Al Pacha, my discovery venue was in the sense of that I was trying to ascertain whether there were any phone calls between the University of Michigan and Al Pacha, especially on July 21st, and particularly in the 6-hour period between the time when Maria Viggers was served upon her the personal protection order and the subsequent time when Al Pacha made his false accusations. I think I have explained this before, but one plausible scenario is that maybe Maria Viggers was served upon her the personal protection order, and then she violated it right away by contacting the university, and then the university, instead of doing the right thing and report Maria Viggers, it might have contacted Al Pacha for the purpose of severing for once and all its relations with me, under the pretext of some whatever conflict between Al Pacha and I. As usual, Judge Kuhnke favored Al Pacha's motion because, again, that's what Judge Kuhnke does when she runs her judicial office. Obviously, Judge Kuhnke was totally clueless about all the evidence that I filed in my lawsuit against Maria Vigers, and therefore Judge Kuhnke couldn't recognize that my discovery venue was useful, and therefore it could also be useful in this lawsuit as well. Here Judge Kuhnke made another one of her lies, this time by stating that all the outgoing calls from the university are masked with the phone number that you see in this transcript, and that therefore any records released by AT&T will not be helpful at all in identifying which office of the university was calling Al Pacha. Judge Kuhnke lied because the University of Michigan is clear in that the telephone number of its administrative employees have the option of not masking their phone numbers. So people like Lady Rasteig or Amy Rano, since they are administrative employees, they have the option, and they usually use that option to not mask their phone numbers when they make phone calls. Then 7 days later, on a hearing on April 20th, I pointed to Judge Kuhnke's lie, and Judge Kuhnke resorted to her argument of, oh, but that was incidental and not material to my decision. The hearing on April 20th was for my motion to recuse. A motion for recusal is the legal and polite way of asking your presiding judge to get the hell out of your lawsuit, because that judge does not have the integrity to continue presiding your case, and your case, like any other judicial proceeding, needs to be presided by a judge who has the moral ability as well as the diligence to conduct the administration of justice. In other words, that is a motion for disqualifying a judge when there is evidence to make the inference that the outcome of your lawsuit is compromised by the personal attributes of this particular judge. By the time I filed my motion to recuse, I just had had enough with this inept judge. Carol Kuhnke had been obstructing justice in both of my lawsuits. By then, Judge Kuhnke had dismissed my lawsuit against Maria Vigers, as I described in the previous segment. And now in the lawsuit against Al Pacha, Judge Kuhnke kept making her sloppy rulings to the extent that at that point I was still unable to take the deposition of Al Pacha, precisely because of the obstructionist ruling that Judge Kuhnke issued on January 20th. I will also mention that by then Al Pacha had produced an affidavit, which is a form of deposition in writing, which she produced in favor of Maria Vigers in that other lawsuit. Interestingly, Al Pacha's affidavit was touching on topics on which I wanted him to testify at his deposition. So it was contradictory that on the one hand Al Pacha was giving testimony to others, but on the other hand he was hiding like a coward by avoiding his deposition in the lawsuit where he was the defendant. Judge Kuhnke is too lazy to read the court documents of the cases she presides, and yet she does not have the dignity to grant a motion for recusal under these circumstances. So in accordance with the way how Judge Kuhnke conducts her judicial office, she denied my motion to recuse. Judge Kuhnke also made her speech in the sense of how she only considers information that is material to the motion that she is deciding at a particular hearing. Regarding the incident with Finley the Idiot's attempt of fraud, which I denounced in September of 2015, Judge Kuhnke made the allegation that she couldn't remember anything about that. So it is interesting that whereas a few months earlier, Judge Kuhnke reprimanded me for pursuing sanctions against Finley the idiot for his attempt of fraud, and Judge Kuhnke made a showing of her delusions. Now Judge Kuhnke was telling me that she just couldn't remember anything about that incident involving Finley the idiot. In the hearings after January 20th, I managed to have Judge Kuhnke establish the 2 deadlines that I mentioned a few minutes ago. Now her dilatory scheduling was reduced or limited in the sense that once I completed my answers to Attorney Gatti's abusive discovery requests, Attorney Gatti will have to take my deposition within 3 weeks. And once I testified at my deposition or upon that deadline of 3 weeks, Al-Pacha will be allowed to continue avoiding his deposition, but for no longer than 3 weeks. I don't know what's so special about the time frame of 3 weeks in the mind of this judge, or why did she use that time frame for each stage of her improvised scheduling. But I must say that that was an accomplishment in my litigation, because otherwise Al-Pacha might still continue avoiding his deposition to this date. Eventually, Attorney Gatti took my deposition, and by eventually I mean pretty much on the deadline, because Al-Pacha and Attorney Gatti were trying to delay as much as possible Al-Pacha's deposition. My deposition was a waste of time. For example, in the initial portion of my deposition, Attorney Gatti was making questions that resemble a job interview. She was asking me about my previous jobs, as if that had any relevance to the defamatory statements that Al-Pacha made in year 2015. Then in a subsequent portion of my deposition, Attorney Gatti asked me to authenticate many of the documents that I had served upon her just 3 weeks earlier. I think that was pointless. I remember thinking, Al-Pacha is wasting I don't know how much money right now with this deposition. I was calculating or estimating that maybe he was spending in that deposition a week's worth of his profit from my work at the University of Michigan. But that's the price that he decided to pay so that he could delay his deposition. Eventually Attorney Gatti made some questions regarding the actual lawsuit, and I also sensed that she was making other questions in trying to discover whether she could file a counterclaim, for example, for breach of contract. But of course she couldn't, because at all times I complied with the employment agreement that I signed with Al-Pacha. Once my deposition took place, the clock started ticking for the deposition of Al-Pacha. That deposition which this fraudulent intermediary had been avoiding to the extent that he preferred to produce an affidavit in my lawsuit against Maria Viggers upon the request from Finley the idiot. By producing that meaningless and conclusory affidavit, Al-Pacha would avert a subpoena for deposition in that lawsuit, and therefore that's how he could avoid the questions that I had ready for him. If I have to give a book title to the transcript of Al-Pacha's deposition, it will be How to Embarrass Yourself Under Oath, Al-Pacha's Deposition Testimony. He obviously was coached by his attorneys to pretend he had severe amnesia during his deposition. He resorted to the answers "I don't know" and "I don't recall" much more often than Amy Carterano did, and that is already a high bar in matters of fake amnesia. Apparently Al-Pacha thought that by sticking to these 2 evasive answers as his mantras or magic words, everything would go away, but he was wrong, because upon further scrutiny or additional questions, Al-Pacha ended up giving what courts call incompetent testimony, as his answers were inconsistent or outright contradictory. One of my early questions was about his interactions with the university's HR department about his employees, and he testified that he does not recall any such interactions. He also testified that he does not recall whether he has spoken with Amy Rano about his employees other than me. It is strange not to remember something like that, because he later testified that I was his only employee at the university in year 2015. It is strange that he does not remember talking about people who do not actually exist. In the first segment, I mentioned that when Al-Pacha came to the building of the university on July 30th of 2015 to announce my termination, he came with a lady whom he presented as his marketing associate. In the deposition, I made some questions about his so-called associate, and he testified that he doesn't know why she went with him. He also doesn't know whether he asked her to go with him to the university. And then he testified that he wanted her as a witness. He's not sure, he cannot say exactly, but yes, he thinks he wanted her as witness. He testified that his so-called associate's name is Tina Richmond. I did some search in the internet, and it turns out that yes, she is into sales and marketing, but according to her LinkedIn profile, she has been unemployed for 11 years, and it doesn't reflect any actual business relation between her and Al-Pacha or his company. For what I am going to say, I want to make it clear. I have nothing against Tina Richmond, and I do not intend to prejudice her in any way. In fact, I could tell that she was uncomfortable during the episode she had to witness, and she shows empathy, which I appreciate. The point I want to make here is that if it is true that she has been unemployed for several years and that the title of marketing associate as portrayed by Al-Pacha was fake, then it is despicable for Al-Pacha to take advantage of somebody unemployed just so that he can have some accessory to appear more dramatic to the University of Michigan when terminating me, and to emphasize the connotation or environment of threats which this fraudulent intermediary falsely portrayed. If that's the case, Al-Pacha should change his company's name from Alpac Inc. or Alpac Inc. to Alpac. It is cynical to use somebody, like in this case Tina Richmond, for the fraudulent theater that Al-Pacha was staging on July 30th. Obviously, somebody who has been unemployed for so long is open to whatever opportunities become available, with the hope that one of them will materialize into an actual employment. That person is not looking to partake in these fraudulent ploys by Al-Pacha arranged with the University of Michigan. This is particularly ironic because this lady earned her bachelor's degree from the University of Michigan. It is obvious that that degree hasn't helped her in advancing her career, and now it turns out that the only way to get closer to the University of Michigan for one day, for a few minutes, is to partake in the theater that Al-Pacha was conducting on July 30th. That is, the University of Michigan's studies apparently do not help someone's career, whereas the University of Michigan makes arrangements and keeps doing business with a fraudulent intermediary. I do not imply that Tina Richmond was aware of the extent of how she was being used. I believe that if she realizes it, she will be indignant. Going back to the topic of Al-Pacha's deposition, I mentioned in the previous segment that Al-Pacha testified that his reason for not showing the university my emails was that that was none of their business, and he reinforced that answer by testifying that the emails constitute private matter between employer and employee. Of course, that is a contradiction. If it was a private matter, as he now portrays, then he should not have talked about those emails during his meeting with the university on July 22nd. To me, the problem is not that he talked about the emails per se. The real problem is that he invented the contents of those emails. That is, he falsely attributed to me statements that I never wrote and I never insinuated. The actual reason for Al Pacha's decision to conceal from the university my emails was that, as I mentioned earlier, that will immediately disprove Al Pacha's fraudulent narrative. One flagrant contradiction by Al Pacha is that he denied that he asked for confidentiality to the University of Michigan. But as we can see in the email he sent on July 21st, where he began his false accusations, he wrote the word confidential in the subject field. Another stupid way of losing credibility was when Al Pacha testified that he did not send any candidates to the University of Michigan in his effort to replace me. Ronald Lovelace, the manager at the University of Michigan, testified that Al Pacha sent a candidate for consideration. One of the key issues in my lawsuit against Al Pacha is a proverb, "What goes around comes around," with which I finished two of my emails to Al Pacha during our failed negotiations regarding the green card sponsorship. It is a key issue because the first time Al Pacha refused to retract his false and defamatory statements, his attorney made the excuse that Al Pacha interpreted the proverb as direct threats. Therefore, it was important to get detail about how is it that this fraudulent intermediary allegedly interpreted a proverb of common usage as if it were a direct threat to him. The proverb is expressed in similar or equivalent ways, and one of the earliest ones is in the book of Job in the Bible. Now, I don't expect Al Pacha to read the Bible because he is neither a Christian nor a Jewish, he is a Muslim. And although I have read large portions of the Quran, maybe he has never opened a Bible. Nevertheless, the idea represented by this proverb is prevalent in the society in which he grew up, and it is also prevalent in the society with which he interacts since the time he emigrated from India. The proverb "what goes around comes around" expresses the idea that a person's evil acts or bad actions have a repercussion on that person. The proverb does not have any indication or any insinuation in the sense that the victim of those evil acts conducts or is even involved in the repercussions of the evil actor. In the emails related to this lawsuit, the proverb expresses my frustration about Al Pacha's erratic and evasive conduct during the green card negotiations. It is ironic that Al Pacha, being himself an immigrant, now was taking such an unreliable approach toward my immigration process by sticking to his false and stubborn comments instead of giving a serious consideration to my supported arguments. Had Al Pacha's employer taken a similar unreliable approach toward Al Pacha's immigration process several years ago, to this date Al Pacha would remain stuck in his native India. Who knows, maybe he will be one of those parents involved in the exam cheating scandal in year 2015. And back then, I didn't imagine that Al Pacha was going to be involved in the fraud with the University of Michigan regarding my prospective employment. When I asked during Al Pacha's deposition about his alleged interpretation of the proverb "what goes around comes around," his answers were, "I don't recall. I don't know. I would explain it to a kid at the age that the kid can understand and comprehend that phrase. Right now I don't have a kid here, so I don't know. You are not a kid." That is not a legitimate interpretation of anything. It was just avoidance of testimony. Al Pacha's attorneys probably know, or should know, that courts do not consider or they do not recognize as threats those which are imaginary or speculative or fabricated by the person who denounces them. I am not talking about Judge Carol Kuhnke's court. I am only talking about decent courts, honest courts. And yet these were the smartest answers that this pitiful intermediary was able to offer in support to his fictitious interpretation of the proverb upon which he bases his false accusations. despite being protected by the University of Michigan for over 3 months and then being protected by Judge Carol Kuhnke for 3 additional months in the form of sloppy obstructionist rulings, Al-Pacha turned out to be utterly unable to articulate his alleged understanding or interpretation of the proverb which he alleges to be the cornerstone of his calumnies. It is obvious that Al-Pacha didn't feel threatened by the proverb "what goes around comes around," because he didn't mention it in his email on July 21st, and he made no reference of that proverb during his meeting with the university on July 22nd. Otherwise, that will be reflected in at least one of the deposition testimonies from the university employees. Instead of making or reflecting any reference of that proverb, the university employees only testified that Al-Pacha attributed to me the statement of threat that once I became employee of the university, I was going to influence the university so as to negatively impact Al-Pacha's business with the university. But that is an extravagant interpretation, as the courts will call it. Just like Al-Pacha didn't feel threatened by the proverb "what goes around comes around," he calculated that the university employees would not perceive the proverb as a threat. That's why he didn't even mention it. The deposition transcript shows that I gave Al-Pacha several opportunities to articulate his understanding of this proverb, this crucial proverb in the lawsuit, and yet he avoided each one of those opportunities by resorting to his evasive and frankly idiotic answers, such as the one that I am not a kid, and therefore he cannot explain to me his interpretation of this proverb. In a desperate attempt to justify his incompetent and erratic testimony, Al-Pacha stated that the interpretation depends on the context. If that were the case, we would not have a brief page from Wikipedia explaining the meaning of "what goes around comes around," and it will be impossible to capture or symbolize the meaning of this proverb in a simple drawing such as the one that Wikipedia has posted. It is also interesting that Al-Pacha testified that he does not recollect whether he ever felt threatened by me during my 7 years of employment with him. Being threatened or feeling threatened is something that anybody will remember, so that was an easy yes or no question. But this is another example that illustrates how Al-Pacha was trying to avoid any and all scrutiny, because he knew that unless he resorted to his evasive answers, he will continue burying himself deeper with all his contradictions and inconsistencies. I am not going to address all the details of Al-Pacha's deposition nor the constant disruptions by Attorney Gatti, because that will result in a much longer video, but I want to comment on an interesting aspect that happened at the end. I wanted to ask Al-Pacha about the context or circumstances of some emails I exchanged with my immediate supervisor at the University of Michigan at the end of 2012 in preparation for my comeback in January of 2013. I had provided a copy of those emails to Attorney Gatti upon her request during my deposition, but I forgot to bring another copy of the emails to the deposition of Al-Pacha. However, I was assuming, or I was expecting, that Al-Pacha would be aware of those communications, because since I provided them to his attorney, then the most reasonable option or possibility was that they will have reviewed the evidence together as part of their discovery efforts. Al-Pacha, as he did during his entire deposition, was also evasive or amnesic about this aspect, and at some point Attorney Gatti asked me in a very confrontational and in a vulgar tone, "What are you afraid of?" No, I was not afraid of anything. The only one afraid during the lawsuit, and especially during that deposition, was Al-Pacha. That's why he had been avoiding his deposition for months, and that's why he has been hiding behind his mommy Attorney Gatti. The fact or showing of how emasculating Attorney Gatti was is reflected in the deposition of Al Pacha, when at some point he asked her whether he could talk because Attorney Gatti just went off with one of her lengthy objections, and Al Pacha wanted to speak. That's what you get when you deal with people such as Al Pacha. When they get busted for fraud, they resort to evasive answers and corrupt lawyers. Al Pacha went from being a Fraudster rat in the dark to becoming a frightened mouse when sued in court.